Okay, so I think we're going to begin. Thank you, everybody, for joining us. This is the first of one of several conference calls that have been scheduled to be part of the launch activities for the Yogyakarta Plus 10 document. This webinar is co-sponsored by RFSL, Outright Action International, and ARC International. And so I'd like to thank them for helping throughout the entire process, but also helping with these webinars. This webinar will be recorded and will be placed on the YouTube site and on the Williams Institute site, and groups are free to link to that recording. And as I said, we'll also repeat this webinar hopefully a few different times for different time zones and different languages. Let me introduce the speakers. Well, first let me go through logistics. You're all, I believe, automatically muted during the presentation part of this webinar. And so if you want to unmute your phone, the command for that is *7. And to mute your phone, the command is *6. Whatever you do, don't put the call on hold. If you have to step out of the conference call for some reason, just hang up and call back. But we don't want to risk hold music. If you have comments during the webinar, go ahead and type them in the chat box that you will see on the left of your screen. And if you don't see that, there's probably a little circle with an arrow or something that you can press to expand it. And what we will do is address comments at the end of the presentation. All right, so, and I think that what I'm seeing is that we don't have everybody muted, so if people could just mute themselves by pressing *6, that would help. All right, let me go ahead and introduce the speakers. What we're going to do for the conference call, or for this webinar, is essentially go down each of the new principles that have been adopted by the expert group and just simply address each of them one at a time and then give some room at the end for some other comments. But we have two very expert speakers. Julia Ehrt is the Executive Director of TGEU, and she's been with that organization in various capacities for, I think, 13 years, and has done a very skillful job, and it was a great pleasure of mine to co-chair a portion of the meeting with her. Our other speaker is Victor Madrigal. He's the Secretary General of the International Rehabilitation Council for Torture Victims. But also last month he was appointed as the UN independent expert on protection against violence and discrimination based on sexual orientation and gender identity. And having worked with him during the Yogyakarta Plus 10 meeting, I can tell that his incredible depth and expertise and precision of thought will benefit all of us as he steps into this 3-year role as the UN independent expert. Okay, next slide. Let me just give some background to the Yogyakarta principles in general. The principles originally were issued in 2007 after a meeting of international human rights experts in Yogyakarta, Indonesia, which occurred in November 2006. And they produced a set of legal standards which are grounded in the human rights that were recognized by international human rights bodies at that time of the meeting in 2006. And so this is one characteristic of the Yogyakarta principles that's very important. These principles are not an aspirational agenda. It's not what we hope to have human rights to be. There's still a lot of work to be done in that area. They are a reflection of what human rights obligations are right now. So we should be able to take these principles to any government and say, these constitute a representation of the binding obligations on you today with regard to sexual orientation, gender identity, and expression, and sex characteristics. The original principles dealt with a number of rights: the right to health, freedom from torture and cruel treatment, the right to found a family, the right to a fair trial, and many of the rights that have been established under international human rights norms. The principles also indicated a shift from the movement language that we all use. In other words, at the beginning of the 2000s, many people referred to the global LGBT movement, and I don't think people were using the I that much at that time, in terms of the population that it served, LGBT people. But the principles are firmly grounded in the notion of universality, in which all rights belong to all people in all countries. And because the Yogyakarta principles are about rights that belong to all people, rather than articulating them as rights that belong to LGBT people in particular, they're articulated as rights that pertain to people's sexual orientation and gender identity. And for the YP plus 10, that's been expanded to include gender expression and sex characteristics. So everybody has a sexual orientation and a gender identity, and these rights are tied to that characteristic for all people. I would note that a global survey of LGBT leaders about, I would say, 5 years ago, cited the principles as one of the greatest accomplishments in the past 10 years, and I'm quoting from the report, because they played a crucial role in establishing a language on SOGI that is now used by a growing number of UN actors and states. And so the principles have been regularly cited at the UN Human Rights Council and by many governments. They've been the subject of legislative policies, executive policies, bills. They've been cited by courts all over the world, and they became quite influential. We knew that they would need some updating, so as is customary in international human rights circles, we looked to the anniversary, and here the 10th year anniversary, to update the principles. And the update was convened by ARC International and ISHR, International Service for Human Rights in Geneva. There were about, I would say on the high end, 35 people, and on the low end, probably about 15 people that met regularly for many months to try to choose and gather experts, particularly experts that have been designated as such in their capacity by the UN. So, for instance, Victor at that point was not the UN independent expert on SOGI, but he had served on the committee that implements the Convention Against Torture and a number of other things. And so if you look at the signatory list of the YP plus 10 document, you'll see several people like that that have served either in treaty body committees or in special mandate positions. I would recommend that everybody go to the website yogyakartaprinciples.org, because that website has all the official documents regarding both the original principles and the YP plus 10 update. And I think now we should go ahead and begin with the first principle. Now, the way the principles are structured, it's about half a dozen new principles, but each principle is accompanied by a number of state obligations. The slides you're going to see has the names and the language in each principle, but it does not have the state obligation language. So sometimes it's important to look at that state obligation, because that's sometimes where the meat of the principles actually exists. Okay, now let me ask, the first principle that we're dealing with is going to be, sorry, I'm just, oh, actually,
Andrew,
no.
I think we're first doing definitions.
Yeah, sorry about that. I was trying to find the right window on my computer screen. So, Julia, go ahead and tell us about the definitions in the YP plus 10 document.
Thanks, Andrew. With pleasure. So other than starting with the principles, I think there's like two important bits that I'd like to elevate in regard to definitions, because as many of you probably will know, that the original Yogyakarta principles spoke about sexual orientation and gender identity. However, the framework of sexual orientation, gender identity kind of has progressed towards, on the one hand, gender encompassing gender expression, and on the other hand, to encompass sex characteristics. So let me speak first to the gender expression question. So when we started writing this document, we realized that gender expression is already in the original Yogyakarta principle, but it's kind of hidden in the gender identity. So now we had a discussion about whether we wanted to elevate gender expression, and for two reasons we wanted to do that and kind of give an explicit definition of gender expression. On the one hand, because gender expression has evolved as a concept as such, and on the other hand, thinking from a discrimination protection type of angle, the gender expression very often kind of is what is kind of perceived and then leads to discrimination. That's why we wanted to have a standalone definition for gender expression, which then, and we landed then as kind of the gender expression being the means to express your gender and gender identity. I'm not going to read this now to you, you can read that yourself, but that's kind of the underlying idea. Secondly, still, as I said earlier, sexual orientation, gender identity, gender expression still falls short of addressing issues that result from kind of the diverse physical features persons have in regard to sex. And hence, as we kind of introduced the concept of sex characteristics, which this one I'm going to read. But first, I want to state that, I mean, this is, you can read this as addressing intersex issues, although on purpose, as Andrew has alluded earlier, the YPs do not speak about identity concepts as such, but speak about general features. But in a sense, from an activist point of view, intersex issues have not been addressed in the original YPs, and adding sex characteristics kind of rectify that omission. And as sex characteristics, as I said, is kind of not as established as, in terms of a definition, as gender identity or sexual orientation is. I'm going to read that definition where we landed. So it says that sex characteristics are each person's physical features relating to sex, including genitalia and other sexual reproductive anatomy, chromosomes, hormones, and secondary physical features emerging from puberty. And sex characteristics as such is an established ground for the protection from discrimination in international human rights law. And then, maybe I should say it has as well relevance to a number of principles in the original YPs. So because we did not want to, repeat all the original principles, we stated then in the preamble that the original YPs should be read as if everywhere where there's sexual orientation, gender identity written, people should think that sexual orientation, gender identity, gender expression, and sex characteristics is written. And by that, we kind of did not have to, re-establish all the original principles through a sex characteristics lens. And then moving on to the further principles, you will see that there's a number of principles in which the sex characteristic has a really prominent part in those principles, but I think that's for later.
Yep. Thank you, Julia. And you point out an important thing that I didn't mention, which is the relationship between the original principles and the YP plus 10. The original principles remain intact as they are. They weren't changed, they weren't altered, so that all governments or all institutions that have referenced those principles, those references still remain undisturbed. The YP plus 10 is a document that is in addition and supplements the original principles rather than replaces them. Okay, so now let's move on to the first of the new principles, Principle 30, the right to state protection. So Victor, tell us about that.
Thank you, and thank you very much for having me in this webinar. Of course, delighted to join you. I think it is telling that the principle to state protection would have been placed in a situation where it can function almost like an umbrella for the additional principles that were actually crafted or identified, I should say. And the reason for this is because I actually think that it is a very good compilation of all of the elements that one could say characterize due diligence in the actions of a state to prevent and punish, prosecute, and provide remedy for violence and discrimination. Now, this is typically the type of scope of obligations that is outlined in instruments such as the Convention Against Torture, which constitutes a veritable strategy to prevent, punish, and eradicate torture and provide remedy. And so I think what this principle does is recognizes that those different elements are all united in what could be called a virtuous cycle. So in order to break the vicious cycle of discrimination and violence, we recognize that the state actually needs to exercise due diligence in preventing, prosecuting, and sanctioning or providing remedy for violence and discrimination. And what you would be able to then see is that after the general enunciation of the principle, there is a series of elements that have been identified in the international jurisprudence or public policy, and that constitute truly a good catalog of best practice in terms of how is the manner in which these violations are actually made concrete. So, for example, you have elements that are as wide-scoping and as general as ensuring measures of education and training and programs that actually aim at sensitizing the judiciary. And then you have issues that are very, very specific but have been identified as very necessary in order to break those cycles. And that's, for example, the data gathering in a way that it's actually allowing to ensure the visibility and addressing violence and discrimination based on sexual orientation and gender identity.
Thanks, Victor. Let's move on to the next one, a super interesting principle. Julia, tell us about the right to legal recognition. I'm not hearing Julia.
I am sorry, I forgot to unmute my microphone. So I agree, it's a very interesting principle, and in fact in the Geneva expert meeting we had very intense and long discussions about how to interpret the right to legal recognition as it is phrased now as Principle 31. The original YPs had spelled out the right to recognition before the law, and the right to legal recognition kind of derives from that law. We gave it an independent principle because the legal development of the last 10 years in regard to the right to legal recognition has been tremendous. And the principle as such was not hard to formulate. It was clear-cut that, well, everyone has the right to legal recognition, everyone has the right to obtain identity documents, and everyone should have the right to change gendered information in such documents. The key question was, where would we land in terms of state recommendations? And for that, it's in fact important to go into those state recommendations, in particular into recommendation A, which I'm going to basically read to you, and it says, so states shall ensure that official identity documents only include personal information that is relevant, reasonable, and necessary as required for a legitimate purpose, and thereby and the registration of sex and gender of the person's identity documents, such as and then birth certificates, identity cards, passports, and driver license. So by and large, what the YP plus 10 recommend to states is ending the registration of sex and gender in person's identity documents because there's no legitimate purpose before the law. And in that vein, the state recommendation again gives some interpretation of how this principle is to be interpreted. And as I said, we had long discussions to conceptualize that, and in discussing whether that interpretation was in line with international law, but we all agreed that it was. However, and that's the second aspect why this principle is special, we as well acknowledged that the current state of play in almost all jurisdictions in the world is a different one. So we introduced kind of a time notion in that principle. And that we did that by defining kind of what we call transitional obligation. And that meaning to make, and the meaning of this is to make the principle kind of applicable at this given point in time where we are at the moment, meaning that, well, until states get rid of registering gender in identity documents, we formulated an obligation of states to ensure a quick and transparent accessible mechanism that legally recognizes and affirms each person's self-defined gender identity. So there's two important aspects in that. One is the state recommendation to end registration because there's no legitimate purpose before the law, and the other one is a traditional obligation that until that has happened, the minimal standard is that people should have a mechanism that allows them to change this gendered information in a quick and transparent way. As I've said, we've had long discussions, and that's what I want to conclude. What is very interesting about that, even before the YPs came out as a document, the German Constitutional Court held in a ruling in November that the way of how Germany registers gender, i.e. only having two options, violates the Constitution. And they argue, and here I quote from the translation, that the obligation to have a legal gender registered in combination with only offering two options, i.e. male and female, does not have a legitimate purpose before the law. So clearly, the German Constitutional Court does not rule according to international human rights law, but the only legal concepts they employ are the right to be free from discrimination, basically, and the right to have identity documents. And so in that vein, and that's kind of, for me, being a German, was very interesting to see that the Constitutional Court comes kind of to the same conclusion even before the principles are out. Yeah, that's all I wanted to say for that principle.
Victor, since this one got so much discussion at the meeting, I'm wondering if you had any thoughts on this. This principle really forces the question, why are gender designations necessary, and when are they necessary, and requires us to really question the assumption that you can put gender designations on a variety of documents that we're traditionally used to. Victor, anything to add?
Well, that question kind of can have two answers. Yes, there's a great deal to add, but I would like to perhaps restrict myself to mention that apart from the precedent that Julia was mentioning in relation to the German judiciary, there is now a very, very fresh advisory opinion by the Inter-American Court of Human Rights, which actually is particularly making reference to how this principle of recognition and right to legal recognition is actually a protected value under the American Convention on Human Rights. So I think that there's a fair deal to analyze from the academic perspective in relation to this.
Thanks. Let's see, now we'll go on to the next principle, number 32, the right to bodily and mental integrity. Julia.
Right, that's me again. Yeah, so I think the principle 32, the right to bodily and mental integrity, is interesting too. So because it kind of has a number of concepts that have already been part of the YP, of the original YPs, but in the original YPs they were distributed to a number of principles. So principle 32, as we have conceptualized it, the right to bodily and mental integrity, kind of establishes kind of the right to bodily and mental integrity, puts together it with the right to be free from torture and cruel, inhuman, and degrading treatment and punishment, and the right to not be subjected to invasive or irreversible medical procedures without free, prior, and informed consent. So all these three principles have been part of the YPs, namely in Principle 4, right to life, Principle 10, freedom from torture, Principle 18, protection from medical abuse. However, what's new in this principle is that it brings those three concepts together and centers it at the core, which is the right to, in fact, bodily and mental integrity. And in that's one of the principles that as well reflects kind of the new addition to the YPs that the concept of sex characteristics brings, because that's an important aspect of this principle. And for that, again, one has to go again into the state recommendation, because what's not written in the principle, but what is clearly pivotal in that principle, that it explicitly extends to the right of children. The background to that, obviously, is that in particular in regard to sex characteristics, one very common and harmful practice is normalizing children with diverse sexual characteristics to match one of the two kind of generic sex characteristics of the two sexes, male and female. And that is encompassed in the state's recommendation. And again, here what is worth noting is that this again connects to directly to the Convention on the Rights of the Child. For example, if you read state recommendation D, which says that states have to ensure that any modification of sex characteristics necessary to avoid serious harm are consented by the child concerned in a manner consistent with the child's evolving capacity, which is directly again taken from the Convention on the Rights of the Child. And again, the principle kind of roots in bodily integrity and autonomy and self-determination.
I think for people working on issues dealing with sex characteristics and intersex people, it's important to look at the details of this principle, because it does place the notion of consent at the very center, along with the notion of medical necessity. So I think this principle will be very useful. All right, so Principle 33, the right to freedom from criminalization and sanction. Victor.
Thank you. I think it's important to begin placing this principle in context of the fact that, of course, this issue was very closely intertwined with the original principles, particularly Principles 4 and 11. I think this is a restatement in the sense that it actually provides a coherent view, very much like what Julia was describing for the preceding principle. And it's clearly placed in a context that I want to make reference to. As of today, more than 70 countries still criminalize same-sex relations. At least 40 countries criminalize same-sex relations between lesbian and bisexual women and other women who have sex with women. Death penalty may be applied in a number of countries of African and Asian region. And I think there is a strong consensus emerging from international law that criminalization of consensual same-sex relations between adults of the same sex violates states' obligations under international law. And specifically including obligation to protect privacy, guarantee of non-discrimination. I think it is telling that this is the theme that was chosen by my predecessor, the first independent expert, Professor Muntapon, as the first underpinning that the mandate addressed. And this topic is actually quite well developed in his first report that he presented last year. Now, the principle embodies this conclusion on the fact that criminalization is a violation of international law, and that everybody has the right to be free from criminalization. It's important to make mention that there was particular care of identifying that this is also applicable and extensible to other forms of sanctions that arise directly or indirectly from the person's actual or perceived sexual orientation, as you can see in the formulation of the principle. Now, the other thing that to me is salient in relation to this is that the recommendations are very much aimed at acknowledging that in the evolution of the process of decriminalization, and Professor Munterhorn was clear at mentioning that that is the tendency towards decriminalization. 25 countries have gone through that process in the last couple of decades. These processes of decriminalization are actually triggered through different state mechanisms. So in some cases it has been the parliament, in some cases it has been the judiciary, in some cases it is a matter of public policy. But what is crucial in terms of our understanding of the principle is that it is not good enough with actually not applying the legislation. We understand that the mere existence of criminalization is actually at the very root of significant violence and discrimination against LGBTI persons. And clearly, this is a matter of formally dismantling any kind of legal provision that is criminalizing.
And Victor, the state actions under this principle call for the repeal of other forms of criminalization that may impact on the rights of people based on sexual orientation, gender identity or expression, or sex characteristics, including criminalization of sex work, abortion, unintentional transmission of HIV, adultery, nuisance, loitering, and begging. How do those other things fit in with SOGI-esque issues?
I think the crucial element to understand is that these forms that you have described, right, are the ones that traditionally have been used as indeterminate figures to actually criminalize or give criminal effects to sexual orientation, gender identity, and gender expression. So one of the most, I think, important conclusions of processes of understanding how discrimination and violence are originated is that in this indetermination, in talking about, acts against decency or morality, in that indetermination lies a lot of the margin that has been utilized historically to actually exercise violence and discrimination. So to me, eliminating those margins is a very important part of the work that we need to ensure is done. You see that in some of the recommendations, there's not only the idea of dismantling, but also providing training, for example, to the judiciary in relation to obligations, so that part of this is the acknowledgement that it's a whole system that has been operating to discriminate and exercise violence.
And Victor, why don't you take us through to Principle 34, the right to protection from poverty?
I think, a lot is being said. Many of the colleagues that are working on these issues will have been hearing about the notion of intersectionality of violations and rights and our understanding of intersectionality. And Principle 34 is a very, very good example of this understanding. Principle 34 is the acknowledgement that there is a right to protection from forms of poverty and social exclusion that are originating in the particular context of this principle, that are originating in sexual orientation, gender identity, gender expression, and sex characteristics. And there is an acknowledgement that historic discrimination and violence against persons on the basis of these categories has created a situation of structural imbalance and placing persons, systematically in a situation of poverty. The recommendations to states, one could see them as an extension of the obligation to prevent and remedy the consequences of violence and discrimination. And I would like to underline that it is possible to imagine that this could be extensible to other forms of violence and discrimination that are originated in reasons contrary to the enjoyment of human rights. I think Yogyakarta, this version of Yogyakarta is actually pioneering the notion of understanding how the idea of redress actually goes well beyond the individual cases. And it actually moves on to the idea of non-repetition by means of adopting measures to alleviate the systemic situation. You see elements that are very progressive, for example, talking about social inclusion and the idea of eliminating systemic situations of poverty, and also providing remedies for the violations that resulted on poverty. And I believe that this is going to give ground to a new generation of discourse in international law to understand the systemic consequences of violations and discrimination.
Thanks. And we've got several really good questions that participants have lined up for us. Julia, why don't you talk about the right to sanitation?
So the right to sanitation, it's a great principle because it does one thing, and that is taking a legal concept that is usually employed in one field and transfers it to another field. I mean, both of the other fields in sanitation, but what I mean by that is that, I mean, the right to sanitation is a clear-cut human right. However, employed or thought in, mostly in the context of the state having an obligation to provide sanitation. So what we did in the YP+10 is taking that right to sanitation and thinking it kind of to the end in the sense of that it's as well about the access to sanitation. Because where's the point if there is proper sanitation, but then the access to sanitation happens discriminatory. And the reason, again, why this is an own standalone principle is because restricting access to sanitation in a discriminatory manner, in particular on grounds of sexual orientation, gender identity, gender expression, sex characteristics, is one of the big backlash topics that have surfaced over the last years. They have been classified as so-called bathroom bills, and there's like a whole zoo of bills that restrict access basically to bathrooms on a number of grounds, restricting it on grounds of having the proper gene pool or so a Y or an X chromosome, etc., etc. So this principle kind of responds to that backlash by taking the right to sanitation and arguing it in the sense of the right to access to sanitation. And then there's a whole, like there's so many areas that are affected by that, ranging from public sanitation facilities to being more specific, schools and other educational institutions, public and private employer settings, entities, could be private or public, that offer services to the public, as well as detention centers. And all these areas where it's specifically relevant to guarantee access to right to sanitation, they then are addressed in the state recommendations. And again, that's kind of why I like the principle of the right to sanitation, because it's an established right just thought to the very end and then employed in a sense to challenge one of the big backlash topics that we're seeing surfacing over the last years. So in that sense, I think it gives a new dimension to the interpretation of the right to sanitation. Yeah, that's why I kind of like that right.
So Principle 36 is the right to the enjoyment of human rights in relation to information and communication technology. This principle recognizes the fact that when the original principles were issued, I don't even think we had Facebook or iPhones or Twitter. And it recognizes that governments censor LGBTI-related materials, often materials about sexual health, civic participation, etc., that the Internet is used by authorities sometimes to identify LGBT people for the purposes of harassment and persecution, and that the Internet is a place which can foster hate speech and hate crimes. The principles reference a number of standards that have evolved since 2007 in international agreements and compacts regarding information and communication technologies, such as the requirement that restrictions by governments on these be proportionate, non-discriminatory, case-specific, at times approved by courts. This principle recognizes the right to privacy from mass and targeted surveillance, and recognizes the right to use anonymity tools, the use of pseudonyms on the Internet, which I think is an interesting right to articulate, and the use of encryption. And let's see, that brings us up to 37, the right to the truth. Victor.
Thank you. Now, all principles are fascinating and extraordinary, but I have to say that I guess each one of us has professional histories that allow us to relate particularly to some of them, and the right to truth is a particular construct that I find very interesting. This is a construct in the sense that it derives from the process of providing justice and ensuring that the fight against impunity in violations also yields an official truth that is that actually has conformity with what actually happened. And I'm sure that very many processes of justice, historical justice, have dealt with this type of processes, but I'm very familiar with the way that this right was actually dealt with throughout the Americas in the context of adjudicating violations from the 70s and 80s. And the whole idea of this construct is that justice cannot be made if the elements that allow to know the truth are not preserved, investigated, and brought up to public light. And it has a very strong connection with reparations as well, with the idea that once justice is made, it needs to lead to the consequence of reparations. Now, right to truth has made its way into a series of instruments of international law, resolutions, judgments, and so on and so forth. So there's a very, very solid set of sources which were recognized when we worked on this right. I would mention two things that I think are salient in relation to this right. The first one is that it has two dimensions. One of them is individual, and it concerns the victim or victims of a violation. And the other one is social because of its very strong connection with non-repetition. The other thing that you will note is that there was a very rich reception of this principle and this construct by the group of experts that actually dealt with this issue in the formulation of the additional principles. And it was linked to processes that were very meaningful in a very, very concrete way to the problematic faced by persons having suffered violence and discrimination on the basis of sexual orientation, gender identity, and gender expression. And you see, for example, things as concrete as the idea of the preservation of medical histories and access to medical history, and the preservation of documentary evidence. Again, this principle is very connected with reparations, and in that, one last word that I think you can make valid for the rest of the principles is I would like to note their strong connection with consequence and reparations of violations.
Thank you, Victor. And let me briefly review Principle 38, the right to practice, protect, and preserve and revive cultural diversity. This recognizes that what many of us call the LGBTI community exists in a variety of different forms throughout the world. and it's important to pay attention, preserve that culture in an environment of increasing globalization. From a development perspective, cultural diversity gives each person an increased number of options as to how they want to live their life. So this can increase development outcomes as well. But this framing of the cultural diversity principle echoes the UNESCO Universal Declaration on Cultural Diversity, as well as references to the right to enjoyment of culture, which we've seen in a number of international instruments. Like other principles that Victor has pointed out, this has both a collective and individual perspective. But I think it will come in particularly useful also in the tension between LGBTI issues and the rights to traditional culture that we've seen proposed by countries at the UN who oppose equal rights for LGBTI people. Okay, so let me go to the questions because there are a number of them. And the first question has to do with, it's a question that arises all the time, and so it's an important one. Are these binding? In what ways are they legally binding, and why do countries have to pay attention to them? And so I'd like the other panelists to comment on this if they want to, but let me clarify that both the original principles and these principles are not legally binding. They were created by UN experts and use the language of UN international norms, but these were not an intergovernmental process. So these can be seen as an advocacy tool so that they may become legally binding once governments adopt the principles as a document. Also, the concepts referenced in the principles are legally binding, even though the principles themselves are not. And one can also see these as part of the way that human rights are created under the international system. It's the voice of the affected people. NGOs and non-governmental entities have a structural place within the UN system. So it's appropriate that these principles are seen as an influential voice in the development of these norms. Julia and Victor, do you want to add anything?
I would just like to mention my, as a complement to your already very comprehensive statement on this. I think part of what is interesting is understanding that international law is an evolving body of work and of human work. And it is accepted that the teaching of highly qualified publicists can be actually a source of international law. Now, I don't mean to say that I self-qualify as that, but I actually think that Yogyakarta in its original form has actually acquired a very significant respect in courts, Supreme Courts and regional courts. The advisory opinion of the court that I just mentioned actually makes abundant reference to Yogyakarta. So while it is true that it's not a treaty and they are not in themselves binding, I think that they have been well tested as sources of interpretation of international law. And in that, of course, part of that very dynamic process.
And let me say, for those people who might be looking for more on this, there's a report on the ARC International website entitled something like The Impact of the Yogyakarta Principles by two authors. The first author listed is Paula Edelbrick. And that was done a few years, I think 2012, so it's a bit out of date, but it's a very impressive cataloging of the many governmental units and organizations that have adopted the Yogyakarta Principles for one purpose or another. Joey, do you have anything to add, or should I go on to the next question?
Go on to the next question. I think I couldn't add anything that you haven't said.
So here's an interesting one. With regard to the principle which was it? Sorry, I've lost count. The right to legal recognition. The question is, if a government lists a third gender as opposed to just the traditional binary of male-female, does that bring the government more closer to compliance with this principle?
I would say it brings the country or the state more closer to compliance, but it still fails to fully comply with the principle. Because I think that the main idea of the principle is challenging what as well Victor said earlier, the notion the kind of generic notion of that gender is part of your legal identity, that gender is generically recorded. And the principle challenges that. It asks the question, does that actually have a legitimate purpose? And that's in the first place independent whether there's 2 options, 3 options, or more than 3 options. It's about the thinking whether that is actually necessary. And the principle argues it's actually not necessary because there's no legitimate purpose. So adding a third gender might bring the state closer to fulfilling the rights to legal recognition. However, from my point of view, the state would still fall short of reflecting that actually registering gender in the first place in ID documents or driver's license doesn't have a legitimate purpose. Do you want to add maybe something, Victor, on that?
I don't have anything additional. I think Julia's answer is very comprehensive.
I've got a question also about how far the principles have gone. So one question is from Boris Dietrich, and I'm just going to read your question, Boris. Andrew, you said the original YPs are intact and the YP plus 10 are a supplement, but the YP plus 10 go further and address new developments. The originals were a codification of existing rights at that point. How do we respond if governments and states say the YP plus 10 is just a wish list of things that we didn't get in the first time around?
Can I
Yep, go ahead,
Andrew,
Victor.
intervene? I would like to make it very clear that the process of identifying the principles was a very careful construct, and that it actually took point of departure in a series of very solid sources of international law. So for each one of the almost words that you see in those pages, there was a process of interrogating whether one could actually find a source that would be solid enough to say that this would be a statement of what international law is reflecting as of today. Now, clearly there are elements associated with the fact that this is not the reality for vast amounts of people around the world, and that's clearly where the agenda lies. But there are sources for each one of the elements that are reflected in these principles. So I would say that rather than a wish list, it is actually an identification of a status of international law on the matter. And just like regional and global courts have acknowledged, international law is not a static body of work. It actually can be recognized to evolve, and this is the reason why this restatement of the principles actually has understood that there have been new angles identified in the 10 years since the first version.
And another question asks, what things did this not cover that we might like to have seen it cover, or that we might like to see 10 years from now? So let me say, as an indication that this was grounded in the current state of the law, we don't see any reference to the right to marriage equality and same-sex marriage because, well, as of last fall, there was no consensus or not even a lot of support amongst international human rights bodies that same-sex marriage was recognized as a right under international legal norms. In addition, we don't see a right or a freedom to engage in adult private consensual sexual behavior. we see that criminalizing this activity is a per se violation of human rights, but we don't see the actual enjoyment of the right. And maybe that will develop in general international law, but since it hasn't already, and this was specifically discussed at the meeting, we felt we couldn't articulate that kind of a right in this document. Let's see. Would Principle 38, is a question, would Principle 38 suggest a protection for Pride events or something like film festivals? That's a principle that I reviewed, but anybody have? I think actually that's one of the purposes of the principle is to address the, in the context of cultural diversity, address the importance of events like Pride events and film festivals.
But I think Pride events are as well covered by the original Why Peace Principle 20, the right to freedom of peaceful assembly and association.
Exactly.
So I do believe one could argue that Pride events fall under 38 by virtue of practicing cultural diversity. However, they for sure as well fall under Principle 20, peaceful assembly.
All right, well, we've gone for an hour, and I wanted to keep our time for that. There are additional questions that are pending, and I'm going to try to work with Winston to get people answers to those. And please go ahead and note for your friends and colleagues that there'll be another webinar that we've scheduled already and others in the future, and that this one will be recorded. I want to thank my panelists, both Victor and Julia, for their very hard work on these principles and for the lot of hard work that's in store for all of us as people seek to hold governments accountable. Thank you very much, everybody.
Thank you very much,
Thank
Andrew.
you. Goodbye.
Bye-bye.
Goodbye.